So I am the last presenter of the conference. I truly appreciate everyone taking the time to be here with us, and hopefully you've all learned a few things today and yesterday. And I just kind of want to wrap things up and kind of talk about how this information fits together. It's really, we do this because we want to help and we want to make the information available to the public. We're an Office of Public Record, and we really want to make everything available out there, specifically on our website and through these training videos, to help hopefully make this process a little simpler and easier to navigate. So that worked. Okay. So hopefully through the course of the last couple of days, we are now able to answer some of these questions, right? What is a water right, and why do we have them? Why are you in this training? What are we doing, right? Water rights are a right to divert and use water of the public for a beneficial purpose. And unlike the East, we have a limited supply. And water is the controlling element in our state. Can you scroll down a little bit, Jim? I think there's some more notes there. Oh, there's not. Okay. So it's a controlling element in our state. And we have these water rights because this is a scarce resource. And as a scarce resource, there has to be an orderly way to distribute that resource amongst those users. And we've developed this water rights system through time to do that. So why do water rights vary? There are a variety of systems across the United States. And that's because the quantity of water available is different depending where you're at in the United States. The systems truly do vary based on the needs of the area. Water, as been mentioned before, has been left to be managed by the state, and each state has developed its own system of water rights. The state of Utah in the 1896 Constitutional Convention talked a lot about how they would deal with water and water rights. In fact, there were two things even mentioned in the Utah Constitution, that the rights existed before statehood and that those rights are going to continue. That's why we have that system of adjudication in the state, so that we can bring all those rights that existed onto the record and hopefully distribute those accurately. It was also talked about that in the Constitution, cities were set up that they can't divest themselves of their water rights, water works, or sources of supply. So it was clear even from our Constitution and moving forward that we needed a clear, clean system, and we needed a system where we knew what water rights were existing and how to distribute them. So in 1903, statutes were passed that required the application process such that we began creating that record. And we've been creating that record now for over 100 years. It was a difficult place to start because we had so many rights that were already existing. But we have come a long way. The adjudication effort that began essentially right after that in 1905, it originally was the courts were doing the adjudication effort, and that it became obvious that the courts needed some help. And in 1919, the statutes were changed to have the state engineer, participate in that process, go out and make proposals, what we call those proposed determinations, to the courts to help aid in that process of identifying water rights. That process has been going on ever since then. this adjudication effort really does depend on the funding from the legislature. We're very grateful that over the last couple of years we've received additional funding, which has allowed us to begin the adjudication, or not begin, but continue and ramp up the adjudication that is happening along the Wasatch Front through the Jordan River drainage, Salt Lake Valley, Utah Valley, up the Provo River. It really is our goal to make all water rights of record so that we can clearly identify how the water should be distributed amongst the users. Let's see. So that water right law that was passed, it had some basic principles that were set up right from the beginning. Water is a public resource. Water is owned by the public. The amount of water under your water right is limited to the beneficial use. That is the limit. That is the definition of your water right. Right from the beginning, there was a forfeiture statute that was set up. If you don't use the water, then it's subject to judicial forfeiture, with the idea that this water can be put to its most beneficial use, to maximize that use through the state. It's clear that the legislature made the conscious decision that water use was a benefit to the public. It is a public good to use water, and that economic benefit that comes from the use of that water. This system, like I mentioned, is different than what is in the East, where there is more water available. You're not allowed in Utah just use water because you have access to it. It was identified right from the beginning, right when the pioneers started to first irrigate, started to first farm in the area, that they were going to need a system to identify and clearly distribute the water. I think it's an interesting thing to note. We talk about our priority system, first in time and first in right. Early on, as you can see on most of our river systems, we have what we call classes of water rights: Class A, Class B, Class C. Because really, when they first started dividing up the water amongst these big river systems, it was done equally, and they shared in the water. But as time went on, as more and more use was occurring on this limited supply, this system developed into this prior appropriation doctrine, where first in time is first in right. Other principles, right? It's our duty to not waste water and to not injure others. Your use is a beneficial use, and you only need the amount of water for your beneficial uses. You don't have the right to waste or use more water than is required for your uses. Also, that last bullet point there, water rights can be conveyed. They're recorded in the county, the ownership. They're transferred by deed. We talked a lot about that, appurtenance, that the sale of land and water is appurtenant and transfers with the land, even if it's not mentioned, unless you specifically reserve them. This was critical, specifically in the early times of the state, where we had all these water rights that weren't even of record. How would they have transferred from one owner to the next if there was no record of those water rights even existing on our books? So it's clear that when land transferred, those water rights inherently went with that land. There is also a small item in the law that I just thought I would mention, that historically you were able to obtain a water right through adverse use. Possession of that water right, but that was made illegal a long time ago, back in 1935. You cannot obtain a water right through adverse use like you can with land. So these are some of the basic principles that I hope that we've come away with through these conferences today to understand with water rights. So hopefully you can answer now these basic questions. When do you need a water right? Well, you need a water right anytime you're putting water to beneficial use in the state of Utah. It doesn't matter how small that use is or large. In 1903, it was clear when those statutes were put into place that all surface water were subject to this application process. And in 1935, the legislature clarified that all waters, including groundwater, also applied. All water of the state, surface or underground, if you're going to put it to use for beneficial purpose, you need to have a water right. So, how do you get a water right? Now, since 1903, you file an application to appropriate with the state engineer's office. The state engineer's office makes a decision, and that state engineer gives you an approval. Then you put that water to use and certificate that use, prove up on it, and you get a vested water right. Many areas of the state are closed to new appropriations, right? So to obtain a water right now, you have to find someone that owns a water right, purchase it, and you file a change application to move that use from its heretofore uses to your uses at your given place of use. You purchase it and file a change. If a water right is a pre-statutory right or started its use before 1903 for surface water or 1935 for groundwater, you're not obtaining a right, but you are filing a diligence claim to bring that water right on the records. It's making a record of an already existing water right. So the state engineer's office, I don't know if we've talked a ton about diligence claims, but I just want to make sure it's clear. We do not approve diligence claims because it's not an approval, but it's just a claim to your existing use. We do investigate the diligence claims that are submitted to our office, and we write a report that goes with the claim that can be used in any administrative procedure thereafter. So it is true, if we believe the claim is not legitimate, we'll put that in that report. So how do you get a water right? You file an application to appropriate to obtain a new water right. You, if you have an existing pre-statutory use, you file a diligence claim, or you obtain a water right from someone else and you file a change application to move those uses for your uses. So to answer that last question there, how don't you get a water right? You don't steal it. You don't just start using the water. If you use water without a water right, that is why we have the enforcement program. And there are some stiff consequences if you do that. So just to reconfirm, where do water rights come from? I've already talked about those first two, applications, pre-statutory use. There are decrees that can come through the courts, either through private transactions or the comprehensive adjudication that we've talked about in detail, which can, a court can decree a water right exists. There's also a very unique and small situation in all of the United States, but in Utah as well, that federal reservations, when the federal government reserves land for a specific purpose, they also have reserved the water inherently in that reservation. This would be for like national parks, military institutions, or Native American reservations. The state has taken an approach here in Utah to negotiate the quantification of these water rights. So these water rights aren't created when we negotiate them. They were created when the reservation was established. And so at this point, their priority date is the date of that reservation. And so sometimes they do conflict with state-based water rights that have been appropriated over the time. because those reservations could have happened long ago in the past. And so we work conjunctively with those federal agencies to help come to a resolution that is hopefully a win-win. An example of this recently is the Navajo Reserved Water Rights Settlement that's been in the news. It's a settlement that was approved by Congress, the last legislative session from last year, and has now also been ratified by the state of Utah legislature. So we're working with them on a fair, good settlement that helps establish a water right for the Navajo Nation that comes out of our compact allocation there on the Colorado River, but fits within our allocation that we have there. So we think that is a very good win for the state of Utah. Let's see. I just wanted to make sure and highlight this here. There are multiple state water agencies, and sometimes we, even ourselves, get confused in working with the different agencies. But we here, through this training, we're the Division of Water Rights, and we're the agency that has the regulatory role to regulate the use or the diversion and use of water. Many times we talk that we deal with the quantity of water. They're also in the Department of Natural Resources, where our division resides. There's another water agency, the Division of Water Resources, and they're the water planning and project development branch of the state. So they have a board, the Water Resources Board, and they do projects to develop and build around the state to develop water resources for the citizens of the state. So we are the regulatory branch. They are the planning and project building branch. And in fact, the Board of Water Resources is many times an applicant to our office and files applications and is protestants to other applications, and is separate from our office here, the Division of Water Rights. Now, in the Department of Environmental Quality, there are two other water agencies. Right? There's the Division of Water Quality, which deals with the control of pollutants on our public waters, regulates the wastewater treatment plants and such, and they have a water quality board. And there's also, I didn't have a bullet here, but there's also the Division of Drinking Water, which regulates water quality standards for our drinking water systems, and has their regulatory role as well. So there are distinct different branches and different state agencies that do different regulatory roles. So the Utah State Engineer follows the statutes that give the Division of Water Rights the authority to make decisions and appropriate the water of the state and distribute that water amongst all the water right holders. All of our decisions at the State Engineer's Office are made under the direction and the name of the State Engineer. There is no superior agency review, and that is very intentional. Right? These are not meant to be political decisions. And in fact, as you can see here on the slide here, the state engineer is actually appointed by the governor for a 4-year term and confirmed by the Senate. All right? The state engineer is supposed to be a licensed professional engineer, and obviously can't do everything on her own, and so has a great staff that works under her direction to make recommendations and helps in administering and supervising the role, right? We have quite a few regulatory responsibilities. The well drilling that you had a presentation on, stream alteration permits, dam safety, adjudication, and this water right application process, which creates this record of water rights, so that one of our most important roles is so that we can distribute that water to all those that are entitled to the use of it. Right? The state engineer many times she is referred to as a gatekeeper to provide that order and certainty, to reduce those potentials for conflict, and to respect existing water rights and protect this important resource in the state. Now, if anyone is aggrieved by the decisions that the state engineer makes, there is a process that we've talked about. You can request reconsideration, or any order of the state engineer can be reviewed de novo, meaning all over again, in the district courts. Okay. So I just wanted to bring this up again, just as our informal administrative process that we have. We've talked about this at length. Applications are filed. We give notice. Protests can be received. We can optionally hold a hearing to gather more information. We study that out and make decisions. We have this reconsideration or de novo review that could happen. Once a decision is made, the water right is then, you have your opportunity to go out and develop that resource. Just a side note, de novo review is with the district court. You don't go to the governor or the department director if you don't like the decisions of the state engineer. They have no authority to change those decisions in the state of Utah. The only option you have is to go to district court. But after you've received that decision, it's your role to develop that water right, put the water use into use, and prove up on it. If you can't do it within a time frame listed, you can file an extension. If you don't do it in the time frame listed and don't file an extension or proof, that water right will lapse and revert back. If you do file a proof and it's consistent, we'll issue a certificate, and you now have a vested water right. There are many appropriation policies over the state. These policies indicate to you, the public, what the state engineer is thinking in those areas. They're a guide to the public of how we're going to act on applications. So this map, I think, has been showed before, is one such policy where areas are open to new appropriation or closed. And so it's a guidance to applicants on how to file applications around the state. I just wanted to put this slide back up again. We've talked a lot about this, but it's a very important principle. Your water right isn't for a volume of water. It's really for the beneficial uses. And those beneficial uses have duties and depletions that help guide how much water is to be used for those uses. Duties, the maximum allowable diversion, amount that can be diverted for your beneficial use. Depletion is the amount of water that was diverted that is actually consumed by that beneficial use. These are just important concepts to understand as you're navigating the water rights process. So it is our role as we look at this through applications to appropriate or change applications or exchange applications that we don't enlarge either the duty or the depletion as you move from one use to another or bring on new uses, so that existing rights are protected. I think this is my second to last slide here. Just wanted to make a note of this. We used to have a presentation on what we call the water use program, and we don't now, so I want to just highlight this one last item. We have a program to collect water use data throughout the state. The majority of the use in the state is still for irrigation. You hear numbers that about 80% is for irrigation. Over the years, we have tracked that use, irrigation, by looking at the irrigated land. It's easy to see if the land is being irrigated or not, so we track it by acreage using aerial photographs. Other uses are not as easily monitored using tools such as aerial photographs. So in the 1950s, we began this program to start tracking other uses such as industrial or municipal use that you can't easily see. And we do this through a self-reporting survey. We send out a survey to all the entities using water and have them self-report how much water they've diverted from the natural system and how much water they have actually provided to their customers. We use this data to help with our own processes, specifically when they're filing proof that they actually have used that water. But there are other entities that now use this data. Division of Water Resources uses it for their planning studies. And as mentioned before, the Division of Drinking Water also uses this data in looking at the source sizing requirements. So the reporting is mandatory, and we work closely with these entities to make sure the data is accurate. We have individuals going around the state, meeting with all of these users, and confirming and working with them as they report that data. I think I had a question come in. Let's see. How do you track depletion to verify a user is not exceeding what is allowable, specifically for municipalities? So we do actually put in our orders that the municipalities are required to track that depletion. And so that is done in a variety of different ways. It really depends, and it's very case specific for each of the municipalities. So it really depends on the treatment system that that municipality has. If that municipality has a treatment system where 100% of the water, like as you can see here in sewage lagoons, is evaporated away, then we'll know that that given municipality is depleting 100% approximately of the water they divert. And so they would be self-reporting and self-showing that they can only probably divert the amount of water they're depleting. Now, if the system is returning a large amount of water back to the natural system and not depleting it, they would then show how much water they're returning back to the system to show that they're staying within their water rights of their full diversion and their depletion, versus what's indoor versus outdoor and whatnot. And so we have certain entities that report that back to us on a case-by-case basis, but that reporting comes back in when they submit proof to our office that they're not using more than their rights would allow under their depletion for their water rights. Hopefully that answers that question. Was there another question there, Jim, or was that just?
I think that was just some information for the exam takers.
So we collect this data, but I do want to make sure it's very, it is a mandatory program, but we are going out there and working closely. We want to be partners with all of these public water suppliers as they report this data. We want to be helpful, and I think we've shown that we do that. If you're a municipality, and if you've worked with us over the years, I hope it's been a good experience as we've tried to help improve that data. With that, I think that ends our conference for the day and for the 2 days. I will take any additional questions that anyone might have on any topic that we've talked about or anything I've talked about today. So are there any questions? Can you click see more there, Jim, so I can see the whole comment, or does he have to do it over there? So I can start reading this question. How do priority dates work on, go back up a little bit.
You want me to read it for you, James?
I can see it now. How do priority dates work on underground wells? For example, if a deeper well has more recent priority date than a shallower well, and the shallow well dries up, what is the responsibility for the owner of the deeper well as far as water use is concerned? Is the owner allowed to keep using water as the right allows, or do they need to stop water consumption? Assuming wells are on adjacent 5-acre lots, i.e. located in close proximity. So water wells is an interesting priority distribution of water in groundwater is done a little differently. So surface water priority distribution, it's pretty clear. We've got a surface source. We determine how much water is naturally flowing on that day, and we distribute that water equally amongst those diverters. You saw from our distribution section, they talk about closing down the head gates. Now, for groundwater, there is a different type of regulation system. And so what we look at in groundwater is to regulate a groundwater system, we have to go through in the state engineer's office what is called a groundwater management plan. And so we will implement a groundwater management plan that will list out how we will regulate groundwater systems. And so if water is being used more than what is annually available to that groundwater system, we will regulate that use also by priority. Now, and so it's done by priority. So the senior water right holder should have priority over the junior water right holder in that situation. But I think what you're talking about here a little bit is about impact from one well to another well. And so for some of those local interference issues, there can be a situation where you can file for interference action against another user, and it has to be, I think the term is, what's that term, Jim? It's like not, what? Well, not impairment, but it has to be a large impact. We realize when you develop the groundwater resource that resource is going to draw down as you develop it. And so we know that some impact is going to come. And so there has to be an impact such that it's unreasonable. I think that was the term I was looking for, from a junior water right on a senior water right holder before that senior water right holder could show that they've been impaired. Unreasonable hasn't been clearly defined, but there is some case law about that. Let's see, there's some other questions. Is there any history in the Utah Lake Basin of having to ration water rights, restrict junior water right holders? So in the surface of the Utah Lake Basin, yes. We restrict water usage in the surface sources every year. I assume this is commonly understood. All the water rights in the Utah Lake Jordan River Basin, all the water is allocated. We are distributing that water and curtailing use every year on that system. There is no excess water. And as far as groundwater systems, we've set a limit of the amount of groundwater that is going to be available to take from the groundwater basin in the Utah Lake system. We have not exceeded those limits at this point, but at some point, if we do, we will restrict the use to those groundwater basins to those limits that we have set. Can the duty in any particular area in Utah be more if the duty in past decades for the area says it could be more? For example, on the Provo River, let's say a past decree like the Hansen decree says that the duty of some areas is 6 acre-feet. What are your thoughts? So we have changed duty in different areas as we've gone through the adjudication. So the duty is dependent on a lot of different things, right? It's not just a volume of water you get. The duty for irrigation is dependent on the growing season, the amount of evapotranspiration that is going to happen for the crops, the delivery system that's there. And so that duty can be changed, and it has been changed for areas as a whole. It's usually a pretty set number for a whole given area. There have been times I know of that through an adjudication or a court process, an individual has requested a larger duty, and through that court process has been decreed a right for a larger duty. However, most of the time, the area, through a given area, all of those rights would have the same duty. Those duty numbers are usually the maximum or the largest amount of water you would need for the most consumptive crops for that area. So hopefully answer that question. Can you define, explain a supplemental right? Sure. So when 2 or more water rights are used for the same beneficial use, we would call those rights supplemental to each other. So say you had a water right from a surface source providing water for 10 acres on a farm, 10-acre plot, and say you had a well that also provided water to that same 10 acres. So the surface source, say it didn't have enough water to provide on every season the whole 10 acres. Maybe some years when it's wet it does, and maybe some years it doesn't. And so they would use that well supplementally to the surface source when it's needed. So those two water rights are supplemental to each other for their common use and period of use and nature of use. And so both of those water rights both of those water rights together, their beneficial use is that 10 acres. And so if an owner wants to sell off that use to someone else, they can't sell off the groundwater right for 10 acres and sell off the surface water right for 10 acres. They have to sell them either together for the 10 acres or separately, one for how much water it supplied and one for how much water the other supplied. Together, they equal that 10 acres. Hopefully that explains or clarifies that.
Yes, I do have one question also with that.
Yeah.
Would the surface water have to be used before you could use the well right, or does one have to be used before the other in that instance?
So it can depend. That's the classic answer, right? It depends. Normally we see that the surface water rights would be used first, right? It's usually cheaper. It doesn't mean that it has to be. If you did not have a surface water right that was meeting because it was curtailed or whatnot, you could use the underground water right to meet the full 10 acres if they're supplemental to each other, clearly and fully supplemental to each other. It really comes more into play when you try to start splitting those uses up and selling them off, how those supplemental natures work. But while they're supplemental to each other, you can use either of those two sources to meet those needs depending on the year and needs for that given area.
Perfect.
Does that answer your question?
Yes, sir.
Okay. Could I define, explain carrier water again? Okay. So we're talking, when we're talking carrier water, we're usually talking water going to a large irrigation company or a district that is providing water to different shareholders or to different locations in their farm. So the carrier water, which is part of that duty, that amount of water you need to get the beneficial uses, the carrier water is the water that's flowing through those canals to help make sure that that water can get all the way to the end of the ditch, right? You might say at the very end of the ditch, you have a user, and say their water right only needs, to deplete 2 acre-feet per acre, but to get that water all the way down to the end of the ditch, you're going to have to send 4 acre-feet to make sure it makes it all the way there, it gets applied to their land so they can meet their beneficial uses. And so the carrier water is the water that is being used to help deliver the water through the system. Okay, how often is a groundwater management plan reviewed and re-evaluated? So there is not any sort of set time frame in statute that determines like a statutory period that you have to review them. But we do go through and review them periodically and establish them. Modifying a groundwater management plan is usually a multi-year process. There is a process that is set up in statute on how you implement a groundwater management plan. And so to follow that process is public meetings, feedback, presenting information, taking public comment, working with the water users of that area. And so it is a very public, open, due process. And so they are not modified and on an annual basis or anything of that nature. Usually what we do is we set these plans with large time frames so that we can evaluate the systems and make sure that we're appropriately regulating them so that we don't impact people when we shouldn't. So I would think that we have, I don't know, Jim, you might looked at about 15 or so, 20 groundwater management plans of different areas of the state. And we're usually implementing a revision or a new plan for one of those areas about every other year. Sometimes we'll do multiple. We've just barely implemented a new groundwater management plan for the Cedar City Valley area, and we're currently working on a plan for the Parowan Valley. Just in the initial phases of that one, and we're doing other initial work in some other areas, but just doing study in some of the areas. If you're familiar around the state, the Pavant Valley, the Milford Valley, a lot of these valleys in the southwestern part of our state. But we have groundwater management plans in the Salt Lake Valley, around the Utah Lake drainage, up in the northern part of the states in Cache Valley, the east shore of the Weber and Davis counties. We have groundwater management plans all around the state. So hopefully that answers your question, Nicole. All right, are there any other questions? Okay, if there are no other questions, I think I'll turn the time back over to Shannon or Vern to kind of give them some direction for the testing that's going on tomorrow. All right.
Okay, great. Thank you, James. Okay. Much appreciated.